person at the Wexford County the Wexford County Jail. Please state your name.
Nathan Crane.
Mr. Crane, you met with somebody from the Public Defender's Office and gave them some contact information. I'm sorry, not the Public Defender's Office, the Community Corrections Office, and gave them some contact information. Is that information accurate?
Yes.
Did you have the opportunity to meet with somebody from the Defender's Office today?
Yes, sir.
But this is case number 254869FY, the people of the state of Michigan versus Nathan Floyd Crane. Mr. Crane, I have a complaint that alleges that on or about November 17th, 2025, in the city of Manton and Wexford County, it is alleged in count number 1 that you committed the offense of interfering with an electronic communication device. That is a felony punishable by up to 2 years in prison and or $1,000. In count number 2, it is alleged that you committed the offense of a domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. In addition, the people have chosen to charge you as a habitual fourth offender, which means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 2-year felony a 15-year felony. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
What's the best option there?
Well, I can't give you any legal advice. You can always request an attorney, the appointment of one, and if you decide. I'm sorry?
I'll probably hire my own attorney, sir.
All right. Do you want the court to appoint one in the meantime?
Sure. Yes, sir.
All right. So we will make a referral to the Public Defender's Office for the appointment of an attorney. Enter a not guilty plea on your behalf. We'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Do you understand that?
Yes, sir.
Prior to that preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show in 04, there was a felonious assault as a juvenile, in 16, a use, in 16, a resist and obstruct, in 20, allowing another to operate in violation of the motor vehicle code. 21, there was a receiving and concealing 1,000 to 20,000, and 3 convictions for possession of methamphetamine. It looks like he was just off supervision on that in September. In 12, there was a minor with any BAC, 11, larceny 200 to 1,000, 15, failed to display a license, and in 15, a domestic violence. Any comment, and the praxis scores him at a risk level 3. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. Just so the court is aware, I did have the opportunity to speak to his family a little bit before this. I talked to his father who wanted to be here today, but unfortunately work obligations, things of that nature. His sister does join us in the courtroom. He has asked for permission. He asked me to ask the court for permission for him to be able to leave the state of Indiana. He does have seasonal work he's been doing for this time he has been in prison, obviously, but multiple seasons. Back to when he was about 13, if I understand correctly. They own a family tree farm, something of that nature. So if the court were so inclined to allow him to do that, I'm told it's barely past the Indiana border, and I'm probably going to butcher this, but Mishawaka or something. I'm probably saying the name of that town wrong. but he would consent to GPS tether for location if the court were so inclined. He does know that would cost $10 a day, but with it working, he'd be able to pay towards that. He does not have any substantial savings for any upfront bond. His family, who does want to support him, also has invested most of their money into the season. They don't make their profits till the end of the season. I believe, Your Honor, you may know something more about the tree farms than I do. But he does have a lot of support from his friends and family, ties to the general area. I even include Indiana in the general area. It's an adjacent state. So I would ask the court to keep the bond as low as possible. I know that might be a lot to ask for personal recognizance due to the fact that he did recently get out of prison. But I would ask the court to consider that, to my knowledge, he does not have any other pending cases in other counties. He's not on any type of supervision. He again would consent to that tether, and his family would be providing him with shelter and employment and things of that nature. Oh, and he would obey any non-monetary bond conditions, such as no contact orders with the alleged victim, no weapons. He did stress to me that he would gladly obey all of those conditions. Thank you, Your Honor.
Thank you. Ms. Lawrence?
Thank you. Unfortunately, I do not have a police report yet, so I am pretty limited on my details. Reading the affidavit, though, this is extremely concerning behavior to the people. It's alleged that the defendant choked the victim. He pulled her out of the car and slammed her on the ground. When the victim said she was going to call the police, he threw her phone and then proceeded to slam her head into a picnic table. Obviously, like I said, I do not have a police report. There's always a chance for amended charges given the seriousness of the alleged facts. On top of that, the fact that the defendant was just recently released from prison and is already exhibiting this type of behavior is also very concerning. Given that, I am going to ask for a monetary bond. I would ask for a $20,000 cash surety bond. I would also ask for a no contact order with the victim, as well as a no weapons and firearms provision. Thank you.
Mr. Hartel, the work in Indiana, is that a Christmas tree lot? Is that what that is? I see a nod in the audience.
I would trust his family to know more about that than I do, but I believe so, yes, Your Honor.
So, Mr. Crane, I want to ask you a couple of questions about that. So
Yes.
I have an address for you in Lake City. Is Lake City your home and you go to Indiana to sell Christmas trees?
Yes, sir.
All right. And is that for the month of basically Thanksgiving up until Christmas?
Yes, sir.
Were you on parole or were you just released from prison?
I just completed parole.
You completed parole. Okay.
Yep, no problem.
And that was for the convictions from 21, correct?
Yes, sir.
All right. Based on the allegation as presented today, I do find that the defendant is a threat. Mr. Crane, as conditions of your bond, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not have any contact with Morgan Golick. I'm also going to order that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior.
Yes, sir.
Bond will be set at $25,000 cash or surety. And while I understand the request to go out of the state, I find that request is just too long of a time period. So I'm going to deny the request for right now.
That's all my money I make though, sir.
Crane, I'm sorry, I'm not giving you permission to leave the state. You're facing felony charges. I'm not giving you permission to leave the state.
Okay.
Thank you, jail. Court next calls the people of the state of Michigan versus Bobby Du Bois, case number 253691 FY. Ms. Carey joins us in the courtroom. Ms. Castles, are you able to see and hear the court?
I am, Your Honor.
And Mr. Du Bois, are you able to see and hear me?
I am, Your Honor.
All right, counsel, we are here for a preliminary examination, but I know there was, the court had received some communication yesterday that there's a request to adjourn today's prelim due to a late appointment in this matter. And given the number of delays we've had in this case, I just wanted it to go on the record before I just flat out grant the request. So Ms. Castles, why don't you go ahead and establish a record if you would, please?
Absolutely. So we were appointed to this matter, I believe Friday afternoon. We received discovery between Friday afternoon and Monday. To my knowledge, we've received all of it. I'm having technical difficulties opening some, but I want to try to troubleshoot that for requesting. So we would just be asking, based on the short turnaround, that this be adjourned out 2 weeks if the court would allow.
Ms. Carey, do you have any objection to that? All right, given the late appointment, the court will go ahead and grant the request. I do find that there is good cause, so we will reset this prelim for 2 weeks. Ms. Castles, anything else?
No, Your Honor.
Ms. Carey? Thank you. We are adjourned on this file. Thank you, Jill.
For accommodating that breakout room as well.
All right, we are back on the record in case numbers 254508 FY and 254631 FY. Ms. Castles, are we prepared to move forward today?
I don't believe so. I'm just requesting a 1-week adjournment. Ms. McNamara has advised that she is not understanding the preliminary examination and the implications of waiving rather than holding. So I've been unable to get an answer as to whether she wants to waive or hold the exam.
Ms. Carey?
Well, I have all of my witnesses here. I will say this, though, there's another complaint that was authorized yesterday or today, I can't remember which, for UDAA that we could do maybe all at the same time. Or at least one is, it's kind of a companion to one of these, so I'm not totally opposed, but.
Has that been sworn to yet? Has been sworn
So
to?
I might have just signed it this morning.
All right. All right.
She has a misdemeanor as well.
Yeah, and that's up for final pretrial on Thursday. I don't know, Ms. Castles, are you on that? Do you know?
On which case?
She's got a misdemeanor.
I don't believe she is.
She's
Is it
not,
the-
okay.
Oh, is it the retail fraud?
It's a retail fraud, yeah.
Oh, no, I'm not appointed on that.
All right. I will grant the request for a 1 week, well, do we need 2 weeks? If that's gonna hit a PCC probably next week, the new one?
Probably, I'm not.
I'm sorry, Ms. McNamara, did you?
I want to get this going. I want to get this over with. So I don't want to adjourn it no more. It just keeps getting adjourned and I just keep
Okay.
getting more and more confused about what the heck is going on.
Well, sounds like Ms. McNamara is expressing her request for a prelim today. So, and I believe she's got that right. So looks like we'll have a prelim. 2 prelims.
Okay.
We'll do 4508 first because I believe that's the oldest one.
I apologize for the inconvenience on this. As I'm not independently able to be appointed to this level of felony case, may I confirm that I'm able to hold this prelim? I'm not certain that I'm able to by MIDC and the appointed.
I'll give you a minute to check on that. I don't know exactly what their standards are anymore, so I'll give you a minute to check on that.
Okay, thank you.
Number 254354 FY. Ms. Castles joins us by Zoom. Mr. Bozak is in the courtroom. Ms. Carey, is this your case?
It is.
Counsel, we are here for a probable cause conference. Is there any resolution in this matter?
There's not, Your Honor. At this time, we're still waiting for the body cam.
All right.
Allison, send me an email because we sent quite a bit,
Okay,
but we sent quite a bit.
of the body cam for Mr. Bozak?
Yeah. You can just send me an email. and tell
Okay.
me what you're-
All right, we will continue this then for a prelim next week with a note that we're possibly still waiting for some body cam. Is there anything else we need to address for the record today?
If I can be heard as to bond.
Ms. Carey, any objection?
We already did a bond motion on the 28th, but I don't know what's changed, and I would prefer these in writing, but for today, I will.
All right, Ms. Castles?
As in terms of the actual reasons for bond modification, they haven't changed too much aside from his circumstances, which just as a reminder that he's never had a failure to appeal. He's local to the area for his entire life, living in Cadillac. And he's going to be released to his mother's house, who advised me that she's willing to ensure he has transportation to get to court and other obligations. Just how long this case has taken, and with our understanding that we haven't received the body cam, and this being through no fault of Mr. Bozak, I would ask that bond be reduced to allow potentially his release. It's currently set at 100,000 cash or surety and has been since October 20th.
Ms. Carey?
Thank you. The people are going to ask the court to find where it's at. He's charged with possession with intent to deliver methamphetamine as a second or subsequent offender, felony firearm. There were just an unbelievable amount of guns confiscated from this property. The property is, I think it's got like 7 trailers on it with different people living in and out of them. He's also charged with maintaining a drug house, and there are possibly more charges for the weapons that may be coming, although we're waiting for labs on that. And my records indicate that we've sent 6 officers body cam and dash cams that we sent on October 24th. So we sent it, I don't know why they don't have it or what they're missing, but they've been given quite a bit. So I don't frankly even know if they're missing anything. I think that Mr. Bozak does present as a threat. Thing is coming up in some other matters right now that are being investigated, and request right now. Thank you.
Ms. Carey, refresh my memory. How much methamphetamine was located?
I just have true narcs right now, so I don't have the actual amounts. To be honest, I don't think it was a lot. I think a lot of it had been sold. So, but I think that the selling is a regular occurrence from the way the report reads.
Ms. Castles, any rebuttal?
Just briefly, I mean, I believe during the last probable cause conference, Ms. Carey put on the record that there were about approximately 16 body cams or officers on scene during the search of his property. So that would be the basis of why it matters that there is still outstanding, if that's the case.
Give me just a moment. So according to the probable cause affidavit, the total weight of the suspected methamphetamine was 16 grams. All right. Looking at the bond factors in MCR 6.106, we looked at one thing is the criminal record including juvenile convictions. In 10, there was a possession of meth in a drug house. In 18, an operating while intoxicated second failed to stop at the scene of a personal injury accident, driving with a license suspended, operating without security, and use of a controlled substance. In 23, there was a use of allowing another to operate in violation of the motor vehicle code. 23, 2 driving with a license suspended, 2 more in 24, and an unlawful plate, and a visibly impaired in 14. Record of appearance, flight to avoid prosecution. I don't have anything to the contrary on that. History of substance use or addiction. Again, we've got prior charges from, albeit in 10, we've got a use in 18, and then a couple drunk driving. So I believe there is a history of an addiction. Character, reputation for dangerousness. The defendant has no assaultive crimes in his behalf, but Ms. Carey talks about, we do at least know that there's 1 firearms charge in this case, and she mentions many more firearms located on the property. Ms. Carey, you'd mentioned you were waiting labs back on the firearms for what purpose?
A lot of them didn't have a serial number, and they were trying to figure out. There's some
Ballistics.
stolen, they're trying to tie them to the stolen ones.
All right. Hold up, Mr. Bozak, I don't want you to say anything because you have the right to remain silent, so I don't want you to say anything that's going to be used against you later, okay? Seriousness of the offense, presence or absence of threats, probability of conviction, and likely sentence. The defendant is charged with the most serious offense with a PWID of methamphetamine, which in of itself is a 20-year offense. But then there is a second subsequent, which makes it a 40-year offense. And also the second or the habitual second. Ms. Carey, have you done any scoring on the defendant yet?
I have done.
Ms. Castles, have you?
I have done, no, I have not.
Well, it doesn't look like the 10-year gap is going to come into play. And a quick scoring off the top of my head, if convicted, would probably put him in a prison cell. Employment and financial status, responsible members of the community, ties to the community. I do know Mr. Bozak has, I believe he's a lifelong resident here, but I know he's been here for quite a while. It's also been mentioned that his mother would step up and vouch for him. Probability of conviction, when I look at the probable cause affidavit, I see that Mrs. Bozak indicates that Mr. Bozak gives her the methamphetamine, so there's a delivery conviction right there, or a potential delivery conviction. Bond was set in this case on October 13th at $100,000 cash surety with other conditions. Again, I find Mr. Bozak as a threat to the community, at least as alleged in the complaint and the probable cause affidavit. I believe bond is appropriately set, so I am going to deny the request. Anything else for the record, counsel?
No, Your Honor.
All right, thank you. Mr. Bozak, you can go with the press. This is case number 254590 FT, appearances counsel.
Nate Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Russell Dutton. He's joined me at the table.
And we are set for a probable cause conference based on the sheet I've received. It does not look like there's an agreement in this case. Is that correct, Mr.
That is
Harrison?
correct, Your Honor. We would seek to have a preliminary exam. I did check the waive 21 days box because he's located in Oceana County. They'd have to bring him back and forth or something.
All right.
I just thought it might facilitate a better conversation in that regard.
Mr. Dutton, have you had the opportunity to discuss the waiver of the 21 days with Mr. Harrison?
Yes, sir, that's correct.
And you're in agreement with waiving the 21 days?
Yes, sir, that's correct.
All right, we will go ahead and we will waive the 21 days. We'll set the matter for a prelim. Mr. Carnes, are you aware of any issues that may delay a prelim?
Your Honor, we do have a potential witness from the state police fingerprint lab. I would ask that person be allowed to testify at prelim by Zoom.
Any objection to that, Mr. Harrison?
You know, I don't like it, but I don't think I have a colorable objection.
I think the court rules allow for it, and I'll find good cause for that, so.
Thank you. I'm unaware of any other issues.
Mr. Harrison, are you?
Pardon me?
Are you aware of any issues?
I am not, Your Honor. That was made just to accommodate the logistics of getting him back and forth if we need to.
All right, then we will go ahead and we will get this set for preliminary examination, and we'll see everybody back in a couple weeks.
Thank you.
Thank you.
Yeah.
All right.
Our next call is the people of the state of Michigan versus Christopher Antonio Cavazos. Cavazos. Cavazos.
Is this you? I wrote on that one, so I'm gonna fill out a new one. Gonna sign a waiver. We both have it.
This is case number 254589 FY, appearances counsel.
Nick Harns on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Bozak. He's joining me at the table.
And we are here for a probable cause conference. Is there any resolution in this matter?
There is not, Your Honor. We are in active negotiations. I've had the prior opportunity to discuss it with him, and I've had Mr. Cavazos execute a waiver of the bind over. There's a little bit of difficulty why I'm stammering is that Mr. Carnes and I signed in each other's place.
Oh,
If you want to redo it, or
You have one.
I do. Sorry. We weren't paying attention. We were signing it very quickly. I apologize. Sign again, please. Okay.
sir, so it's my understanding you're agreeing to waive the preliminary examination, agree to be bound over to the circuit court. Have you had adequate opportunity to discuss that with Mr. Harrison?
Yes, sir.
All right. Mr. Harrison, do you have the bind over?
I will present it to you.
Is there anything we need to address before I sign the bind over?
Not at this time, Your Honor.
Mr. Carnes?
Not on behalf of the people, thank you.
Another question. That was my bad, I'm sorry.
Okay, I've signed that bind over, and